Karens do some interesting things. They really make you wish that being a Karen was illegal. Well, today we'll be looking at Karens and Karen-like convicts going at it against judges. First up, we have the time this judge came face to face with a male Karen as a witness.
I'm a witness, okay? Okay, what I'm saying is, he is present, and he's chosen not to step up there. He's asking not for appointed lawyer. He doesn't need an attorney.
So you're acting in the capacity
I'm not
of lawyer?
acting. I'm a witness. This is an American national.
An American national.
The court reporter has to be established before anything can proceed.
Well, okay, well, get up in your seat now, and we will wait for that. We have some preliminary thing.
We're all waiting for the court reporter to be...
Do it now. All right, this is State versus Henry T. Eldon Jr. Mr. Eldon, I need to have a seat at the defendant's table.
But things escalated quickly.
You are going to be held in contempt.
All right, Mr. Eldon, can you just stand up for me, please? Turn around, place your hands behind your back, if you would.
And who are you? And do you have a warrant, a signed warrant?
I do not have a warrant. I've just been made aware by the judge that he wants me to take you into custody for obstructing judicial process, okay?
How do you plead?
I would like to see your oath of office. I'd like to see your letter accepting and acknowledging your office. And I would like to see the same for the prosecuting attorney. And to know the names of everyone in this room. I need that before I understand what's going on, sir.
So the answer, and I will answer for him, is not guilty. Okay?
I haven't made any plea, nor should you make one
All
for
right.
me. I don't accept that.
Okay.
I don't accept anything that's happened to today. I did not in your own position.
Score him out.
Up next is another lawyer who thinks he can do whatever he wants. They are the new Ken breed.
You have previously indicated that you wished you had your AR-15 to protect someone's property, correct?
I'm going to ask you to go into the library again for a moment, please. Please don't talk about the case.
Mr. Binger is either forgetting the court's rulings or attempting to provoke a mistrial in this matter. He knows he can't go into this, and he's asking the questions. I asked the court to strongly admonish him, and the next time it happens, I'll be asking for a mistrial with prejudice.
First of all, Your Honor, this was the subject of a motion. I'm well aware of that, and the court left the door open.
And now hear what the judge has to say to him.
For me, not for you.
My understanding of
You should have come and asked for reconsideration. You did on the one motion, and in fact, I granted your motion for reconsideration.
That was on our motion.
Excuse me. I did. I granted.
We did not move
that
to
was
reconsider.
their motion.
We have not filed any
me.
motions to reconsider in this case.
That was their motion for reconsideration, which I denied. But I said I denied it, or I indicated a bias towards denial is what I did. Held it open with a bias towards denial. Why would you think that that made it okay for you, without any advance notice, to bring this matter before the jury? I was astonished when you began your examination by commenting on the defendant's post-arrest silence. That's basic law. It's been basic law in this country for 40 years, 50 years. I have no idea why you would do something like that. And it gives, I'll leave it at that. So I don't know what you're up to.
May I respond?
Yes.
We filed an other acts motion on this exact issue because, in my mind, and I argued this, it is identical to what was going on the night of August 25th, in the sense that the defendant was using this exact same weapon. He was using it in a manner to try and protect property.
No, he wasn't.
Your Honor, with all due respect...
I'm not going to rehash the motion. That's absolutely untrue.
This next convict was trash-talking when he had no reason to. But again...
Mr. Rhodes, you can just bring him up right here.
Why y'all have me come out like this for?
I think you know why.
What?
You know exactly why. Now, listen, stop talking. Have been...
Oh my God.
Are you done?
No, I'm done.
You've been charged in the 4th degree. I'm going to keep talking because I don't want to have to see you back here for this.
What you think? Look at What you think that? Out of that. I ain't do.
So you're saying you're going to find out where I'm out?
Out of that. You got something, I'll be out.
Okay.
Yeah,
You've been charged with
okay.
assault in the 4th degree,
I don't
minor
care about
injury,
none of that.
terroristic threatening in the 3rd degree with physical contact. New charges. I'm entering a plea of not guilty on your behalf. Would you like me to
I'm not
read the
guilty.
arrest warrant to you?
No, I'm not guilty.
I am setting a bond of $15,000 full cash on that on those charges, and the other case, once this actually gets served on you, is going to be dismissed without prejudice as duplicate.
But now the judge fights back.
Not guilty.
I just said that.
I'll be out.
Okay,
All
I
right.
just said that.
All right.
And
Take
would
me
you
back
like
to
an
my cell.
attorney?
Take me back to my cell.
I'm not taking you anywhere. They can take you back, but would you like an attorney?
All right.
Okay, Ms. Shoring, that was a threat against the court. I think that I'm asking the county attorney's office to take that into account and consider what to do with that.
Next, we have a woman who was in court for domestic violence. This is what the judge told her.
No contact means you can't call him, you can't write him, you can't text him, you can't email him, can't leave a message on some social media, you can't go visit him. If you go someplace, even though you may have arrived first and one of them shows up, you have to leave.
So you gonna tell me I can't go home?
I'm telling you, you can't go home. If you live with Mr. McRae, you cannot return to that residence.
Oh, but how you just gonna tell me I can't go home though?
What?
How you gonna tell me I can't go to my home?
I just did.
Fair enough, because she abused him, so she really should not be allowed to go near him, whether it's their joint house or not.
How you gonna tell me I can't go to my home?
I just did.
Well, I bet I do.
Well, then you're in contempt, young lady, and you've got 30 days. So you're not going. You're not what?
Whoa, whoa, whoa.
Get back! Get back!
You just said I got 30
Get
days.
back!
I'm not getting nothing else.
That's another 30 days. That's 60 days.
So what?
90 days.
So?
120 days.
Okay, and?
180 days.
Whoa! He's quiet. Get off me! Get your hands off me, man!
Next, we have a Karen from the jury who is clearly unorganized and intentionally being rude to the judge.
Let me be clear, if I wasn't before. Because if these don't have anything to do with your next witness, then why are we having the jury wait outside right now?
Just because we were trying to move everything in, because in terms of timing, we do it now.
In terms of timing, it would be much better to do it during the lunch break, when the jury needs longer than you all. So we'll go ahead and pass on this. Let's bring the jury in, please.
Your Honor?
Yes?
At this time, the defense rests, other than putting in our records.
And now for the judge to fight back.
I just want to say, this is the most uncalled for, unprofessional way to try a case. You all knew about this, and even if you didn't make your decision till this morning, to have 22 people plus all of this staff and every attorney march into court, be waiting as if it's some kind of game. Now I have to send them home. The state's not ready. They're not going to have a witness ready. We have another day wasted. I honestly, I have never experienced a level of unprofessionalism in my career. It's unbelievable.
So, Judge, if we had any pretrial matters, you asked us to be here at 9:15. We were here at 9:15 to discuss pretrial matters. I have been practicing in this county for 22 years.
You know what, I don't want to hear it. I don't want to hear
Well, Judge, you're insulting me on the record in front of my client, and I believe that I should be able to
Okay,
defend myself.
you can do that later. You can make your record later, but you've been insulting me the entire trial. So, blatantly, taking your headphones off, arguing with me, storming out, coming late intentionally if you don't like my rulings. So, quite frankly, this has been long overdue. So please be seated. You can receive the evidence. I will receive the evidence. And then you can put whatever you want on the record at the end.
Now we have another Karen lawyer that is so rude and disrespectful. The judge puts her in her place.
Okay, I don't buy that.
Well, Your Honor, that's how it is.
What I'm telling you is, have you discussed this issue with Mr. Freakouts?
Yes, I have in the hallway.
Okay. And has it been a matter of making demands or saying, what are we going to do?
No, it's a matter of calling my client.
I do have experience with you using inappropriate language.
And you know that I would admit it if I had done it. And if I was going to do it, I would have done it to her face.
You know what? You want to be a sailor? Fine. Go be a sailor in your private life. But don't be a sailor in my court or in my cases.
I didn't.
Again, I don't judge people with sailor language because I use a little sailor language, but only in my private life. Not in my courtroom, not to a litigant, not to an attorney. I don't do that because that's not professional. And ma'am, I warn you, one of these days, the State Bar is going to catch up to that. Because if you read the rules, there is an ethical rule about fairness to opposing counsel.